Good day, Crime Talk aficionados. We have some breaking news for you. That's right. An arrest has been made in the death of 9-year-old Melanie Buzzard. We're going to talk about parricide. That's right. The rare crime in high-profile cases like Nick Reiner. A horrific attack on an elderly woman. Oh, wait for it. Yeah, the guy has a lengthy criminal record. A pastor is indicted for his weird conduct related to his wife's death, which was ruled a suicide. Alec Murdaugh's attorneys, well, they're optimistic of a new trial, as am I. Have some advice on what not to do when your date says she just wants to be friends. An attorney is going to prison for violating the rules of don't steal your client's money. We've got this day in legal history, our quote of the day, which has to do with plea bargains, which, well, I've been thinking a lot about lately, and then our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, you know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell so that you receive notifications. And I was looking through the comments last night, and I'm not saying this to just say it, ladies and gentlemen. Many people say, oh my gosh, I got unsubscribed for no reason. So they have to resubscribe. So please do that. Thank you. And remember, you can also check us out on any of your favorite podcasting apps. All right, so let's get to it today. It is already Tuesday, December 23rd, 2025. And since it is Tuesday, that means we'll also be going live tonight, our Tuesday night live program, 6 p.m. Mountain Time. Join us tonight. We'll have a lot to talk about. Obviously, the breaking news, an arrest in the death of 9-year-old Melanie Buzzard. Coincidentally, her mom, last one seen with her. And obviously, we'll talk about the case of Nick Reiner as well. Let me also remind you to go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone in the United States that you desire. You're going to get a report literally prepared as you wait. It's going to have all types of information, cell phones, emails, social media presence. You're going to find out if somebody has liens, judgments against them, criminal history. Are they on one of those lists that you have to put yourself on? Yes, find out if somebody's coming into your life, or, you know, maybe you deciding somebody needs to exit your life. Go to crimetalksearch.com. Find out. Knowledge is power. Let me also remind you, time is running out. Get that gear. If you want it by Christmas Day, we could probably still get it, but you got to order now. So hit the links below as well. All right. Like I said, it is Tuesday, December 23rd, 2025. And first on the docket, breaking news. That's right. The body of 9-year-old Melanie Buzzard has been found more than 2 months after she went missing in Southern California. Now, according to law enforcement sources, and this is just breaking, the body was found in Utah earlier this month. Her mother, Ashlee Buzzard, was taken back into custody. As you may recall, she was previously arrested on an unrelated charge where it got thrown out at a preliminary hearing, and she was later released. Now, how did this case all start? School officials reported Melody missing back in mid-October of this year. Police said that Melody and her mother were seen at a rental car business in Lompoc, California on October 7th, right before the two headed out on a multi-state road trip. Melody was wearing what appeared to be a wig to disguise her natural hair and a hooded sweatshirt with the hood up. Police believe that Ashlee Buzzard returned from the road trip without her daughter. Now, police also say that Ashlee Buzzard has been uncooperative with investigators and has not provided any information as to her daughter's whereabouts. Now, here's the weird part. They're not going to do a press conference until 2 p.m. on Tuesday of next week. But a couple things come to mind here. Where are they going to file charges as it relates to the death of Melody? The body was found in Utah. It would seem to think that that's probably where they're going to file charges. Obviously, because that's where the murder took place, right? The Constitution says you got to be tried in the jurisdiction in which the crime was committed. However, if the police can somehow say that she was dead in California, and maybe like stuffed in a trunk or something along those lines, it's going to depend upon the cause and manner of death, where they can determine the actual homicide took place. Or who knows? We know it doesn't work like in the Brian Walsh case, to say that she died of natural causes and I panicked, so I buried her in the desert. That kind of thing doesn't work. Either way, charges are coming. I'm surprised it took this long, but apparently the police knew about this. They discovered the body in early December, and obviously they were probably waiting for DNA results, autopsy information, any sort of toxicology. That usually takes some time. So the police were waiting. We were wondering why no steps were taking place, but I'm sure the police were watching mom before today, and now, like I said, she's been taken into custody. All right, next on the docket, parricide. What the heck is parricide? That's the act of killing one's parents, and it remains one of the rarest forms of homicide. Approximately 250 parricide cases occur annually here in the United States, with fewer than 20 involving the killing of both parents, known as double parricide. Now, this incident predominantly involves adult offenders, most often males. Obviously, a recent case involving Nick Reiner, who's charged with the stabbing deaths of his parents, filmmaker Rob Reiner and photographer Michelle Singer Reiner, has brought some renewed attention to this phenomenon, its rarity, and the profound question it raises about family dynamics. So there are apparently 4 primary categories of parricide offenders based on extensive research and case evaluations. Now, these classifications help explain the motivation behind such acts, according to researchers. Now, the severely abused offender, this is the type typically involves juveniles living at home amid prolonged physical, sexual, verbal, or psychological abuse, often accompanied by neglect. The act stems from desperation in which the offender perceives no escape or fears imminent harms to themselves or their siblings. Now, these individuals usually have no prior criminal record and are described as good kids trapped in intolerable situations. Well, then we got the severely mentally ill offender, right? In this category, they often have a history of severe mental illness, such as schizophrenia or bipolar disorders with psychotic features. The homicides may occur during a delusional episode, triggered by hallucinations, voices, or perceived divine commands. Medication noncompliance frequently plays a role, and obviously there's been some reports to indicate that Nick Reiner has been prescribed medication for schizophrenia prior to the incident. Now, obviously those have not been released by police authorities, but that's what's coming from some of the family members and his defense attorneys as well. Then we got the dangerously antisocial offender, motivated by selfish gain. These individuals view parents as obstacles to personal desires, such as inheritance, money, or freedom in relationships. And they exhibit patterns of manipulation, deceit, grandiosity, and lack of remorse, often alleged with antisocial personality disorder diagnosis. Then we've got the enraged offender, driven by intense rage from unresolved conflict. This type may arise from prior abuse or, conversely, overindulgent parenting that fails to foster frustration tolerance. And when boundaries are finally set, such as demands of self-reliance, the offender reacts with explosive anger. Yes, you ever see that video where the dad dumps all the guy's video games and he runs it over with a lawnmower? That kind of reminds me of that last category. And, oftentimes I don't talk about cases that are ongoing, but we have one here, very interesting, where, maybe somebody who's got out of the mental institution for years and years and years, and then maybe went home and did terrible things to his mother with a shotgun. Parricide. It's a thing, ladies and gentlemen. But once again, after 30 years of criminal defense, I told you we've handled just about every type of case. So we kind of know what we're talking about. Anyway, deciding which category is applicable requires, obviously, investigation. You want to do some interviews, review mental health records, as well as family insights. And that's what the defense in the Reiner case will be doing, is putting together a mitigation package to show some sort of mental disorder, schizophrenia, something along those lines. So how does this affect the Nick Reiner case? Well, obviously, Reiner remains in custody under heightened supervision as a standard precautionary measure, and the legal proceedings are obviously ongoing, and he doesn't appear in court again until next January. Now, obviously, the defense is also going to have to look into mitigation, whether it's for a plea, maybe to go to the hospital versus prison, or even if the district attorney were decided to go with the death penalty. There's obviously a lot of history of substance abuse, beginning with Mr. Nick Reiner at the age of 16. He attended the Second Nature Academy, which is a wilderness therapy program in Utah, amid concerns over school refusal and early drug experimentation. Now, some former participants have described it as harsh conditions, including outdoor living in extreme weather, limited bathing, and intensive group therapy, though the program defends its approach as compassionate and licensed. Now, Reiner later publicly discussed his experience there, including subsequent heroin use linked to contacts made in treatment. Now, his surviving siblings, Jake and Romy Reiner, are planning a memorial service and have expressed gratitude for public support while grieving privately. Now, let's not forget, ladies and gentlemen, we're going to bring you a show about Brentwood. Not exactly the peaceful little enclave people think that it may be, but there's some other historical cases of parricide or intra-family violence. First, Marvin Gaye, going back to 1984. The renowned Motown singer was shot and killed by his father, Marvin Gaye Sr., during a domestic dispute at their LA home, and that stemmed from longstanding family tensions as Mr. Gaye Sr. was convicted of voluntary manslaughter. Phil Hartman, remember him, the comedian actor known for his work on Saturday Night Live and The Simpsons? He was shot and killed by his wife, Bryn Hartman, who subsequently died by suicide. Obviously, that was a tragedy, and left their two young children orphaned. How about Jennifer Hudson? The actress and singer's mother, brother, and young nephew were murdered in Chicago by her estranged brother-in-law, who was later convicted of murder. Kelsey Grammer, the actor, endured multiple losses, including the murder of his father back in 1968 and his sister in 1975 by separate perpetrators. You just never know where it's going to happen, ladies and gentlemen, and it can happen to anyone. That leads us into our next story. How about a horrific attack on an elderly woman? Take a look at this video and take a look at this piece of wood with a bolt screwed into it. Yeah, that was used on December 5th to hit a 75-year-old woman by the name of Jeanette Markin. And it was completely unprovoked in downtown Seattle, Washington, near the King County Courthouse at the intersection of 3rd Avenue and James Street. Like I said, look at this video. The footage indicates that the perpetrator, identified as 42-year-old Fale Pei, P-E-A, or P. Anyway, he approached Miss Markin from behind while she was awaiting a crosswalk signal, picked up that board and struck her in the face, which had a screw that was protruding. The impact caused severe injuries, including fractures to her nose and her cheekbone, as well as permanent blindness in her right eye because the bolt or the screw gouged her in the eye. Now, thank goodness bystanders promptly assisted Miss Markin, providing her aid and photographing the suspect, which facilitated his rapid identification and arrest by the King County Sheriff's deputy. And body cam footage from the responding Seattle Police Department officers revealed that P or Pei, just call him horrible human being, was immediately recognized as a known individual with a history of, wait for it, random assaults. And wait for it even more, he has extensive criminal history, including multiple misdemeanor assault convictions. 1 in 2024, that's the most recent one. 4 in 2023, and 1 in 2020. And 8 bookings in the King County Jail in 2025 alone for various offenses, though no charges resulted from those prior to this particular incident. What do we say oftentimes, ladies and gentlemen? Past performance is indicative of future results. If people are committing violent crime, they need to be locked up. It is a fundamental principle in criminal law. If someone is committing violent crime, you have to lock them up to the point that They are too old when and if they ever get out of custody to be able to harm anyone ever again. Well, Mr. P, or Pay, faces charges of first-degree assault with a deadly weapon, and his bail was finally set at $1 million, citing that the judge finally came to the conclusion that it's pretty strong likelihood that he would commit further violent offenses if he was released. Yeah. Now, guess what? A competency hearing has been scheduled following concerns raised by his defense attorney regarding mental health issues. Once again, another big shocker there, right? If you also go take a look at the criminal justice system, particularly violent offenders, and we're not talking, like gang violence type of stuff. We're talking where people just randomly go assault somebody. Mental health issues. Once again, more than likely issues that have been identified and people are ignoring them, or basically they just go through the motions and nobody ever gets fixed until we send them off and warehouse them in prison, ladies and gentlemen. Well, needless to say, Miss Markin's family, including her son, has expressed profound distress over the randomness of the attack and has questions regarding public safety policies permitting repeat offenders to remain at large. And a community-supported GoFundMe campaign has been established to aid her recovery, addressing medical expenses and a loss of her independence as she's no longer able to work or drive. Yeah, and don't forget, the 75-year-old woman is now blind because a man randomly decided to shove a bolt that was attached to a board into her eye, ladies and gentlemen. Unbelievable. And eventually, and I get it, I'm a criminal defense attorney. If somebody gets charged, we will zealously protect and defend their rights to the bitter end. All right? But as a member of the community, the purpose of government has one purpose. Go back to all the political philosophy throughout history. What is it? The government is supposed to protect their people. That's it. Protect their people. That's what the government is supposed to do. You're on your own for everything else. The government is supposed to protect your rights by making sure other people don't violate your rights. That's what the social contract was about. It's about being able to live your life without somebody else violating your rights, like being able to walk down the street and not get a freaking 2x4 thrown at you or swung at you that has a bolt in it that's going to blind a 75-year-old woman. And unless and until people start getting fired or arrested for letting these people out, which probably will never happen because the judges have immunity, but these district attorneys that allow this crap to go on need to be recalled. And any member of the community that doesn't want safe streets, they're on drugs. They have to be on drugs, or they're living in a complete bubble and complete naivete that they think everything's going to be fine. Next in the docket, federal indictment issued against a pastor in regards to his estranged wife's death. Now, this is weird. A federal grand jury has indicted John Paul Miller, a 46-year-old former pastor from Myrtle Beach, South Carolina, on charges of cyberstalking and providing false statements to federal investigators. The allegation stems from conduct directed towards his estranged wife, Micah Miller, spanning from November of 2022 until her death of 2024 in April. Now, Micah Miller was only 30 at the time and was discovered deceased in the Lumber River State Park located in Robeson County, North Carolina, back in April of 2024. Police determined her death resulted from a self-inflicted gunshot wound, officially ruling it as suicide. Prior to her death, the couple had separated, and Micah Miller had initiated divorce proceedings shortly beforehand. According to the indictment, John Paul Miller is accused of engaging in sustained course of harassment. This reportedly involved sending numerous unwanted communications, on occasion exceeding 50 contacts in a single day, interfering with her financial matters and daily routines, installing tracking devices on her vehicle, damaging her tires, and disseminating a nude photograph of her online without consent. Well, that's not a very godly thing to do, former pastor man, is it? Anyway, prosecutors assert that these actions placed Micah Miller in reasonable fear of death or serious harm and were likely to inflict substantial emotional distress. Additionally, the charges include allegation that Miller misled investigators regarding his involvement in damaging her vehicle's tires. Evidence reportedly indicates he acquired a tire deflation tool online and communicated with others about her car. Now, if convicted, Miller faces a maximum penalty of 5 years imprisonment for cyberstalking and 2 years in prison for the false statement, along with a $250,000 fine. He's scheduled for an arraignment on January 12th of next year. They're in Florence, South Carolina. That's a weird case to me, ladies and gentlemen. She commits suicide. Are they somehow saying that he led to her suicide, hence the reason for the extreme emotional distress? I don't know. It's very odd to me. And normally when you have that, you want the victim, the prosecutors want the victim to come in and say, this contact was unwanted. It caused me emotional distress. It was done with the intent to harass, annoy, alarm, and intimidate. I think this is going to be a difficult one for the prosecution to prove without her being there to do it, right? She's not there for court. She's not subject to cross-examination. So anything she would have said previously to investigators doesn't come in. It's going to be an interesting one. Next on the docket, Alec Murdaugh's defense attorneys express optimism over the former clerk's guilty pleas in this misconduct case. And I do too. I think if Alec Murdaugh is going to get a new trial, it's going to be because of the clerk, and it's going to be the 404B evidence that we have previously talked about. So Alec Murdaugh's defense attorney, Dick Harpatulian, and I'm sure I mispronounced that, but we gave it our best shot, has stated that the recent guilty plea by the former Colleton County Court Clerk, Rebecca Becky Hill, to ethics-related charges strengthens the case for a potential retrial. So old Dick described the team's outlook as cautiously optimistic ahead of oral arguments scheduled before the South Carolina Supreme Court on February 11th in 2026. Now, as you may recall, Murdaugh, the disbarred attorney, was convicted in March of 2023 for murdering his wife, Maggie, and son, Paul, at the family's hunting estate back in June of 2021. He is serving 2 consecutive life sentences without the possibility of parole. While the consolidated appeal includes standard challenges to trial rulings as well as allegations of improper conduct by Hill during the proceedings, defense attorneys contend that Hill made inappropriate comments to jurors regarding Murdaugh's demeanor and testimony, potentially influencing the outcome. Hill then pled guilty earlier this month to 1 count each of obstruction of justice and perjury, along with 2 counts of misconduct in office. These charges stem from providing access to sealed court exhibits, including crime scene photographs, to media representatives, and subsequently providing false testimony under oath. Additional misconduct involved improperly allocating bonuses to herself and using her position to promote a book about the trial that she wrote. Well, a circuit court judge sentenced Hill to probation, noting that a harsher penalty would have applied if evidence of jury tampering had been established. Anyway, Hill has consistently denied attempting to influence the jury in that particular case. I don't believe that statement at all. I think she hated the man. I think, and let's get for real. Alec Murdaugh killed his wife and son. It's not a whodunit, in my opinion. That video, the Snapchat of him down there by the kennels that was captured with his voice on it, clearly puts him there at the time of the murders. But the man could have walked if they hadn't brought in all that 404B evidence and potentially, Miss Hill influencing the jury, because some of the jurors did say they were influenced, but it wasn't enough to, really sway him. But it made inappropriate comments for sure. Dick Harpatulian emphasized that Hill's admission to perjury during a prior evidentiary hearing undermines her overall credibility. Because remember, the judge that held the hearing as to whether there was misconduct questioned her credibility. Basically said, I don't believe you, but I really don't want to set this guy free or give him a new trial, right? Anyway, he argued that the appellate standards informed by the United States Supreme Court and federal circuits precedent requires only demonstrating that extraneous comments could reasonably have affected a juror rather than proving that they actually influenced the juror. He says that the integrity of the judicial process is paramount and highlighted multiple grounds in the appeals that could warrant a new trial. Separately, Harpatulian has recently published a true crime memoir titled Dig Me a Grave: The Inside Story of the Serial Killer Who Seduced the South. Now, this was co-authored by a woman by the name of Sean Ashlee. The book details his experience as a prosecutor back in the 1980s in the case against Donald P. Wee Gaskin, a notorious South Carolina serial killer executed in 1991 after convictions for multiple murders. Old Dick reflects on the complexities of capital cases and the justice system's operations based on his decades in the courtroom. Now, the Supreme Court there in South Carolina will determine whether his convictions stands or whether a retrial is ordered. I think he's going to get a new trial, ladies and gentlemen. Just saying. We'll see how it goes. You never know. We'll all find out at the same time together. Next on the docket, what not to do when the woman you go on a date with says she just wants to be friends. So police in Boca Raton arrested a 41-year-old local resident after an alleged confrontation that originated from a dinner engagement and escalated into reports of erratic behavior involving a firearm and some property damage. Sounds like the perfect date, does it not? Anyway, according to police accounts reported by local media, the incident began when Derek Hurwitz and a woman dined together. During the meal, the woman reportedly emphasized that their relationship was completely platonic, prompting an unfavorable reaction from Mr. Hurwitz. Later that evening, Mr. Hurwitz allegedly arrived uninvited at the woman's residence, where he displayed some agitated conduct. The woman informed officers that Hurwitz retrieved a black handgun from his possession during the encounter, though he reportedly neither aimed it at anyone nor issued any threats. She further stated that Mr. Hurwitz collided his Cadillac with her vehicle before departing the residence there. And while officers were documenting the woman's statement, Hurwitz reportedly telephoned her, and when a responding officer spoke to him, Mr. Hurwitz allegedly responded with aggressive and profane language. He subsequently agreed to meet with the police at his residence for a little further discussion, called getting arrested. Upon officers arriving at Hurwitz's home, he briefly opened the door before attempting to shut it, while issuing verbal insults to the police. As the officers prepared to leave, Hurwitz allegedly exited his residence, approached them rapidly, positioned himself in close proximity to one officer, and grasped the officer's vest. Hurwitz was taken into custody and booked into the Palm Beach County Jail. He now faces charges of battery on law enforcement officer and resisting arrest without violence. As of the latest reports, a combined bond of $5,000 was set for his release. Now, the investigation remains a little ongoing. They need a little more details regarding the potential further charges related to the showing up with the gun to your date's house after she said, it's just going to be platonic. One way not to end a date, ladies and gentlemen. Maybe you should do that over the phone, I guess, at least with Mr. Hurwitz. Next on the docket, attorneys going to prison for violating one of the simple rules of being a lawyer, right? I've told you, and if you ever want to be a lawyer, you have to pass not only the bar exam, but you also have to pass the multi-state ethics exam. And here's the general rules that you need to know for being a lawyer. 1, don't sleep with your client. 2, don't steal their money. And 3, don't abandon the client, which means you paper them with paperwork so that they know that you're working on the case and that they need to communicate with you and you're communicating with them. Simple rules. Well, like I said, a stark reminder that not all risks pay off at the table. A Florida elder law attorney has been dealt a severe hand by the justice system. 25 years behind bars for pilfering nearly $2 million from vulnerable clients to fuel what he alleges is a gambling habit. Please meet Jason Penrod. Once the proprietor of the family elder law firm, a firm now shuttered amid scandal, was sentenced by a Polk County judge by the name of Cassandra Denmark. The punishment includes an additional 15 years of probation upon release, ensuring a prolonged oversight of his future behaviors and money management. Penrod entered pleas of guilty back on December 12th to 2 counts of grand theft and 19 counts of money laundering. Investigations reveal that he had siphoned funds from clients' trust accounts and directed substantial sums towards some high-stake wagers at the Seminole Hard Rock Casino in Tampa. The scheme unraveled when a former colleague at the firm detected some irregularities in clients' accounts and promptly alerted the Florida bar. Penrod himself later confessed to the Florida Supreme Court regarding misappropriation of funds from 2 clients. Police arrested him back in September of 2024, culminating in his permanent revocation of his law license the following November. Adding irony to the proceedings, Penrod had previously faced a civil suit from the adult children of one of the affected clients. Court records referenced a candid admission from Penrod in which he described his compulsion as a, quote, raging gambling addict, a self-portrait that proved all too accurate. Anyway, the case is obviously a big, huge breach of trust in the legal profession, tasked with safeguarding, the elderly, transforming what should have been a secure little nest egg into fleeting chips at the casino floor. Don't steal clients' money. Next on the docket, this day in legal history. On December 23rd, 1783, George Washington appeared before Congress in Annapolis, Maryland, and formally resigned his commission as Commander-in-Chief of the Continental Army. This act set a powerful precedent for civilian control over the military and shaped later constitutional understandings of separation of power and executive authority. November 23rd, 1913. President Wilson signed the Federal Reserve Act, creating the Federal Reserve System as the central bank of the United States. The statute fundamentally reshaped U.S. financial regulatory monetary policy and federal oversight of banking and remains one of the most consequential regulatory laws in American history. That's right, the Federal Reserve, the people that set the interest rates, the people that print money. It's never been the same since. Your dollar's never been worth less. Buy gold, ladies and gentlemen. And on this date, on December 23rd, 1914, Congress amended the Judicial Code to allow Supreme Court to have certiorari to review certain state court decisions that sustained federal claims or rights, not just those denied them. This change broadened the court's discretionary control over its docket and strengthened federal oversight of state court interpretation of federal law. And on this date, on December 23rd, 2004, the Commercial Space Launch Amendments Act. It updated federal law on commercial space flights by refining licensing liability and safety framework for private launch and reentry activities. It lays much of the legal groundwork for today's commercial space industry and FAA regulatory regime over space transportation. There's actually an area of law, ladies and gentlemen, called space law. I went to a CLE years ago down in Dallas, and it was an aviation law CLE. I was there with a friend of mine. I was like, space law? I never heard of it. Who knew? Now look at it. It's huge. All has to do with airspace, putting stuff up into space. Whose space is space? It's actually quite interesting. And then on December 23rd, 2004, Congress passed the Video Voyeurism Prevention Act, which made it a federal crime to knowingly capture an image of a person's private area without consent in a situation where a person has reasonable expectation of privacy, particularly in federal jurisdictions like federal property or on special maritime territorial jurisdictions. And it's a key expansion into the privacy laws. So yeah, don't go putting cameras and taking pictures of people's private parts on federal land, ladies and gentlemen. It's against the law, just like it is in state privacy areas as well. Next, our legal quote of the day, a notable legal quotation regarding guilty pleas. Well, and it comes from Brady v. United States, 1970 Supreme Court case, authored by Justin Byron Whizzer White, former running back at the University of Colorado. His quote is, quote, waivers of constitutional rights not only must be voluntary, but must be knowing, intelligent acts done with sufficient awareness of the relevant circumstances and the likely consequences, end quote, right? That's why courts engage in colloquies when people plead guilty, to make sure that what they're doing is a knowing, intelligent, voluntary act and they're aware of the consequences, i.e. they're going to prison, they're going to get probation, maximum penalties. All right. The next one, or this statement obviously underscores the constitutional requirements for a valid guilty plea, emphasizing that, like I said, it must be done voluntarily made. Another pertinent observation from the same opinion highlights the practical realities of plea decisions. The state, to some degree, encourages pleas of guilty at every important step in the criminal process. Often the decision to plead guilty is heavily influenced by the defendant's appraisal of the prosecution's case against him and by the apparent likelihood of securing leniency should a guilty plea be offered and accepted, end quote. Obviously, these principles remain foundations in assessing the validity of guilty pleas under the United States. And I've been giving that a lot of thought lately because, sure, people plead guilty all the time to things they didn't do. I get that. If you get a speeding ticket, they have you plead guilty to a defective headlamp and you take your 2-point violation and you move on. But what do you do when somebody's always maintained their innocence, but they say they want to plead guilty to avoid the greater consequence, even though it's going to result in a lengthy prison sentence? And everything that the person says, once you explain it, it's a personal decision to plead guilty, that they say they're not guilty. Do you let the person plead guilty? Can you stop the person from pleading guilty? Guess we'll have to find out. Next, our dumb criminal of the day. In Polk County, Florida, a seemingly neighborly gesture took a decidedly unneighborly turn when a simple beer delivery devolved into a backyard brawl worthy of a cautionary tale. Please meet Charles Johnson, our dumb criminal of the day. And evidently in dire need of refreshment, politely requested that his Eagle Lake neighbor replenish his dwindling beer stock. The Good Samaritan complied, only for gratitude to evaporate faster than an open can on a hot afternoon. What began as a minor disagreement swiftly escalated. Johnson allegedly seized a freshly delivered bottle by the neck and pursued his benefactor across the lawn like a man defending his last cold one. The neighbor, sensibly alarmed, retrieved a firearm from his vehicle and issued a stern warning. Johnson retreated, at least temporarily. Emboldened, or perhaps further lubricated by prior consumption, Johnson charged again. This time, the neighbor opted for a more direct approach, a solid punch that floored the aggressor, and according to Sheriff Grady Judd, administered a good old fistful of noogies. Apparently so forcefully that the blow of the heavily intoxicated Mr. Johnson, upon regaining his senses, called 911 to report that he had been pistol whipped. Sheriff Judge later clarified the confusion by a characteristic dry amusement. The only weapon involved was a clenched fist that evidently felt like artillery. Deputies sorted fact from inebriated fiction and arrested Johnson on the charge of aggravated assault. As the sheriff summed it up, the perpetrator now resides in jail, beerless, unpistol whipped, and nursing both a bruised face and a thoroughly ruined evening. One is left to ponder the timeless lesson: never bite or bottle swing at the hand that is going to provide you a beer, I guess. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, join us tonight, 6 p.m. Mountain Time, for our Tuesday Night Live. And remember, the Constitution matters.